Hello, good morning, everybody. Thank you so much for joining us today for my HR Council's third Tuesday webinar. And backed by popular demand, new laws your company must know about for January 1st, 2021. So I first did this presentation early 2020, definitely not knowing what was going to happen with the pandemic and all of the craziness that would ensue. But I did an overview like this of all of the new laws coming out for 2020, and I guess people really liked it. So I'm really happy for that, but it does put a big burden and challenge on me to try to get through all 50 states in 1 hour. So if you joined us before, you know it's a very quick hitting, none here, this one here, this one here. So there's a little bit less law changes than I had anticipated. Actually, it appears that July 1st of 2020 was the bigger date for new laws coming out, and where January 1st and July 1st tend to be the two big days that new laws become effective. What we've actually been seeing in the last couple of years is laws that are effective on October 1st and September 30th and May 1st, and they're all over the place. And so doing a, sort of January 1st, July 1st check-in before would have been pretty much it. But now what we're seeing is a lot of laws coming out on very seemingly random time frames. So a lot of that's obviously in response to the COVID-19 pandemic, but it's been like that since before 2020. So we have a little bit lighter of an update today, but I still have my work cut out for me. So I'm well caffeinated. I've got my coffee here. I've got water. I'm ready to do this for you guys. So along those lines, I just want to touch on a little bit of the housekeeping for today. As always, it does remain the same. I will be sending out a recording of the presentation today to everybody in attendance and everybody that registered. You'll also get a copy of the slide deck, so you'll receive the deck as well. Those of you that have a need for HRCI recertification credit, we will be doing one HRCI recertification credit for this, and everybody that attends the full presentation today will get that code sent to them via email. We'll send you a survey so you can let us know how we're doing, and if you want me to do this presentation in July again, let me know that too. I tried to sort of plan ahead and put a few upcoming dates of effective laws in this webinar for you guys too. So look for all of that, and then of course you guys are all muted. So any questions you might have, please feel free to type those into the questions box there, and I will get as many of them answered as I possibly can. And like I said, the agenda, 50 state legal update, that's it, and that's all. So if we can get through these 50 states in the next 55 minutes, I'm going to feel really good about myself, and then I'm not going to talk for the rest of the day. So, all right, so let's go ahead and get this kicked off. Starting out easy and slow, we've got Alabama. There are no upcoming new laws in the state of Alabama relating to labor or employment law. Lots of minimum wage changes. So this is nothing new from the last time I did this presentation. The minimum wage changes across all 50 states they're mind-blowing, and they're happening fast and furious. And many of these states have indexed increases. So at one point, the state legislature said, hey, we're going to increase the minimum wage, and it's going to, automatically increase to this on January 1st, 2020, automatically increase to this on January 1st, 2021, and so on and so forth. Not all states are indexed that way. but a number of states are, and it's worthwhile to make sure that you're paying attention to all of those minimum wage updates. Alaska's is a statewide. We have lots of states that have their own city and county minimum wages that we'll be diving into as well. Arizona's minimum wage is increasing to $12.15 per hour. So make sure that if you're an Arizona employer that you are brushing up your payroll to make sure you're getting your employees the proper minimum wage there. Another trend that you guys will notice a lot in the presentation today is marijuana law. There were a number of ballot initiatives that voters got the opportunity to have their say on in the November election. And marijuana, as it turns out, very popular amongst the electorate. If there was a ballot initiative anywhere in the United States, it passed. And Arizona is no different. So Arizona, voters passed the Smart and Safe Arizona Act, and that legalized a small amount of possession and use and actually sale of marijuana or THC concentrate. And this is, like I said, for recreational purposes. And very much like what we'll see with most other ballot initiatives, the initiative itself was silent as to what the implications would be for employers. Now, for those of you that are in Arizona, you know that, for example, the medical marijuana law in Arizona, employers are required to consider providing accommodations to employees who use marijuana under the state disability laws. And whether that will extend to recreational, we don't know. Less states provide protections for recreational marijuana users than they do for medical marijuana users. So it remains to be seen. It appears that maintaining drug-free workplace policies are enforceable. And always remember that marijuana does remain for now. We might see a change on this as well, which would make the patchwork of laws much easier for multi-state employers to comply with if they did this, but it's possible the federal government may consider decriminalizing marijuana. And if that's the case, then we have something different to look at here. But for now, it looks like drug-free workplace policies prohibiting, positive tests for recreational marijuana use are going to be valid. Arkansas, here the minimum wage is going to go up as well. On January 1st, 2020, it'll go up to $11 per hour. You can see that this was part of a series of annual increases that started a couple of years back. So all Arkansas employers need to be aware of that minimum wage. And everybody's favorite, California. California is always busy. So doing a presentation where I just focus on laws that are coming out 1/1/21 is really difficult because I worry that I might be missing things. But if I look at even a couple of months before or a couple of months after California new laws relating to employment law, it gets very unruly. So I tried to limit it as much as possible to things that were very, very new and things that were coming out on 1/1/21. So California is one of those states where there are a ton of different minimum wage levels. So one of the increases relates to small employers, and that's companies that have 25 employees or less. That minimum wage is going to $13 per hour, and employers that have 26 or more employees, that's going to go up to $14 per hour. So, slowly rising up there. We also have some city and county minimum wages that are going to be increased. $15 per hour seems to be a fairly common stopping point for a lot of jurisdictions with their minimum wage. That's not everywhere, and of course California would go above and beyond, like Belmont, Santa Clara, and Santa Rosa have decided to do and go over 15. I suspect, in some of those places, $15 an hour is minimum wage. still isn't going to help people very much making a living wage, but nonetheless, here's what the minimum wages are in those jurisdictions. This is so one of those things where I decided to throw in something that was that's older than January 1st, 2020, because I think it's very, very important that California employers know about and take very seriously Cal OSHA's new emergency temporary standards as it relates to COVID-19 programs. And there's a number of requirements that were passed here. And like I said, this went into effect already at the end of November. So for several of these, employers have to develop a written COVID-19 prevention program. Hopefully you guys already had one of those written. We call them a pandemic response plan, but essentially it's a document that talks about the requirements for testing and notifications and employee training and things like that. So talking about all of the changes that you've made to your workplace to prevent COVID-19 spread in the workplace. Make sure that that plan goes out to all employees. There is a corresponding training requirement. So there is the requirement that you train your employees on your COVID-19 prevention program. Employers have to, and this is new, this is different, provide testing to employees exposed to COVID-19. And Cal OSHA specifically said that employers should offer testing to potentially exposed employees at no cost and during working hours, as well as inform employees of testing resources. So to comply with these, Cal OSHA in their FAQs, which are actually fairly helpful, so make sure you check those out if you're in California, but might be wise for California employers to vet and line up some third-party testing resource so that employees with any potential exposures can be tested really quickly. There's also a requirement that employers notify employees of any potential exposures within 1 business day and have created a notification obligation that's different from the COVID-19 related notifications that came out of the passage of AB 685. So again, a lot of new stuff to be paying attention to here. There's also a lot of record keeping requirements and requirements to report serious illnesses to Cal OSHA and other public health agencies. So as always, California not making it easy on California companies, but a few things to keep in mind regarding those new emergency temporary standards. And here's a litany of other things that California has done as well. So a few things to note: the statute of limitations for wage and hour discharge and discrimination complaints was increased from 6 months to 1 year. So this effectively gives employees a longer period of time to bring complaints regarding wage and hour discharge, and I think will also correspondingly allow employees more of a bite at the apple. They're going to have a longer period of time, which of course is just going to open employers up to more of these types of cases. Something that's kind of interesting and that I think HR reps really need to be aware of is if you are a company that employs minors, HR representatives are now considered mandatory reporters of child abuse and must receive training on how to notice, how to report, and what to do about potential child abuse of minors that are working for you. So this puts another big burden on HR representatives because now you are a mandatory reporter. So if you have if your company employs minors, make sure you understand and get that training and know what the obligations are on you as far as that mandatory reporting goes. If you have let go an employee and are going to be entering into a separation agreement and release of claims agreement with that particular employee, a lot of times the companies like to put in those separation agreements, a provision that says you agree that you're not going to try to get a job here again, we're not going to hire you, you don't even try. Well, now those no rehire provisions are much more limited, especially in situations involving claims of harassment and sexual assault or criminal conduct. So be aware, make sure that when you are providing that separation agreement to your employees in California, that you look at whether that no rehire provision, if you use them, is going to be okay. There's also been an expansion of leave for victims of domestic violence, sexual assault, and stalking that would include leave for any victim of a crime that caused physical injury or mental injury with a threat of physical injury. So you've got to, if you have an employee come to you and ask for this type of leave, make sure you understand all of the reasons that a victim might be able to use this type of leave. California did what the federal government tried to do with the EEO-1 report. And again, this is going to create another burden for California employers because now there's new pay data reporting requirements. And so employers that have 100 or more employees in the state of California need to report pay data based on race, gender, or race and ethnicity, gender, and what's the other one? Now I'm blanking, of course. But there's and pay data. I'm sorry, you have to report the pay data. But there's this reporting requirement, and it is going to be a burden. So make sure you understand what those requirements are for your company and how you're going to collect and sort that data. The biggest one here I kind of saved for the last, the California Family Rights Act. So this is the leave law that provides leave to California employees for things like bonding with a new child, and those types of leave applies to much smaller companies now. It's been expanded to employers that have just 5 or more employees. So most companies in California are now going to need to comply with the CFRA, which also means that if you're a California employer, you need to update your employee handbook and make sure you're providing all the proper notices. So if before it applied to companies that have 50 or more employees, now it's just companies with 5. Significantly expanding this, also expanding some definitions of who can use the leave and things like that. All right, Colorado has been a very interesting state lately. Colorado has been getting into the mix very much like Nevada, like New Jersey, where they have passed quite a few employee-friendly type laws, and 1/1/21 is not going to be any different. The statewide minimum wage increased to $12.32 per hour, and so has the tipped minimum wage. So now employees that are tipped have to be paid $9.30 per hour as of 1/1/21. The Denver area minimum wage is going up to $14.77 per hour. So be on the lookout again for those state and city-specific minimum wages. Colorado did make some changes to their unemployment compensation program. So employees who have to leave work for domestic violence-related safety reasons remain eligible for unemployment benefits. Previously, that was not seen as a legitimate reason to not be employed, and so those types of victims could be denied unemployment benefits. But one thing that's interesting now that Colorado changed is if you have an employee depart and you pay them a severance when they leave, that pay is going to be deducted from unemployment compensation. So it doesn't mean that they won't ever get unemployment compensation, but it will take away from the total amount of unemployment that they will be able to get because of that severance. Colorado also has a new pay equity law that requires, that pay be fair amongst the various genders and races, and there's some reporting requirements with that as well. So make sure if you're a Colorado employer that you fully understand that new pay equity law and the requirements that it puts on you. The big thing here that I think is really worth pointing out is Colorado passed a statewide paid leave law. And so now, as of 1/1/21, for companies that have 16 or more employees are going to be eligible to accrue at least 1 hour of paid sick and safe time for every 30 hours worked, up to a maximum of 48 hours per year. So if you are a company, for example, that has PTO that is meant to encompass vacation and sick and personal days, you need to make sure that your PTO policy allows employees to accrue paid leave in at least as favorable of terms as this new paid sick and safe time does. If you have separate vacation and sick leave policies, make sure that your sick leave policy provides the required amount of leave and is as generous as this. As of 1/1/22, that's when this law will apply to all companies, regardless of size, but for the first year, it'll be just those 16 and up. Connecticut has some new laws. First, they established, this was back in 2019, Connecticut established a paid family and medical leave program that's funded through payroll deductions. So again, that passed back in 2019, and there's, employees can't take the leave until 2022, but what the January 1st date is for is that is the date that employers have to begin making those payroll deductions that are going to fund that program. So make sure you understand, what the deductions need to be, and that those begin January 1st of 2021. Here's a minimum wage increase that is on August 1st, 2021. So like I said, traditionally we looked at January 1st and July 1st as the two big dates for new laws to come out. Well, here's an August 1st, 2021 date. Why August 1st? I don't know, but here it is. Please make note of it if you have employees working in Connecticut. All right, Delaware. So Delaware, very easy. Minimum wage is increasing to $10.25 per hour. District of Columbia, this one surprised me, and I kept looking and looking and looking because I thought District of Columbia, again, has been very busy with new laws, relating to, requirements that third-party payroll providers be used, that sexual harassment training be required. So I thought for sure I was missing something with DC, but there's nothing for 1/1/21. So I did put in that as of 10/30/2020, there were some new posting requirements employers needed to be aware of, and those relate to employees' rights under 11 different employment statutes, things like the Living Wage Act, the DC Human Rights Act, the DC Family and Medical Leave Act, and it was incumbent on the mayor to create a website that describes the employee rights and to put those posters out there. And so in addition to the required poster, employers in DC have to print copies of the information posted on that mayor's website and put it in a binder, and have a copy of that binder available at every location where the summary poster is displayed. So a number of requirements for DC employers that were effective back on 10/30/2020. So make sure, if you haven't done it already, that you check that mayor's website and find all these posters that you've got to put up. At least DC does that. I found with usually they make things very difficult on DC employers, but usually their mayor's website, they have a fair amount of good information and detail for employers. So it could be worse. It could definitely be worse, but they try to give I think employers a lot of information on that website. A couple of things in Florida. Again, so this is a different effective date, so 9/30/2021. So maybe put a tickler in your files now, but effective that date, the minimum wage is going to increase to $10 per hour. And this is 1/1/21. Every public employer or somebody who has a contract with a government entity or is a subcontractor of a government entity has to enroll in and use the E-Verify system to verify the work authorization status of all employees. So if you are an employer that wouldn't normally have to use E-Verify, if you do have those types of public contracts, start now. E-Verify, once you get the hang of the system, it's not bad, but there is lead time and some learning that needs to be done about, temporary non-confirmations and how to get, access to the system and kind of get the lay of the land. So if you are one of those employers, make sure that you start looking into this now so that you're ready for 1/1/21 when you would have to start using E-Verify. In addition to, you're no longer able to just do a Form I-9. There's my word. Georgia is busy. I'm able to scoot right by Georgia without mention, but Georgia's gotten a few things. This is not new, and this actually goes back to August 5th, 2020, but Georgia requires that lactation breaks in the state be paid. So mothers who are expressing breast milk during the first year of their child's life now actually need to be paid for those lactation breaks. There's only, to my knowledge at this point, one other state, Illinois, that requires lactation breaks be paid. Usually, employers have to provide the breaks and they have to provide a separate room that's not a bathroom, that has a lock and things like that. But now in Georgia, these breaks need to be paid. So if you've got employees that are breastfeeding or that are expressing breast milk for their child, make sure that you are providing paid leave for those breaks now. That's a big difference as of August 5th. There's also a law regarding criminal background checks that allows individuals who are rehabilitated. So this would be individuals who, were convicted of a crime several years back and they have served their sentence, they've served their parole or probation, they've reintegrated into society. Those individuals are going to have the ability to petition the court to seal certain criminal records and prohibit use of that information if there was ever an action against an employer for the employee's action. So some new background check laws, those don't come up very often. So I thought that was kind of interesting. And as of 1/1/21, any employees who are experiencing student loan repayment garnishment, those garnishments will now be limited to 15% of an employee's weekly disposable earnings. All right, Hawaii made some changes, fairly minor, but if you are very lucky and are in Hawaii, changes were made to the domestic violence leave statute. So employees seeking to take leave due to domestic violence reasons, employers are now more limited in the types of documents that they can request to verify that employee is indeed a victim of domestic or sexual violence. So if you're in Hawaii and you have an employee seeking this type of leave, make sure that you understand the types of documentation that you can and cannot ask for. Again, it's a sensitive topic, and Hawaii did a really big retooling of their whole domestic violence statute. That's actually fairly interesting. If you're a law nerd like me, check it out. I think they did some good things in Hawaii. All right, Idaho has none. Illinois, again, minimum wage. So effective 1/1/21, it's going to increase to $11 per hour. Again, it's got indexed increases up to 15 by 2025, hitting that magical $15 per hour point. The tipped employee minimum wage is going up to $6.60 per hour, and so I'm making note of that. The Chicago Fair Workweek Ordinance has been in place for a while, but starting on 1/1/21, employees are now going to have the right to file a private lawsuit against employers if they violate that particular ordinance. And so for those of you that might have employees working in particular industries in the city of Chicago, you know that you have to provide certain amount of notice of an employee's schedule, of schedule changes, things like that. So if there is a violation, employees are now given the green light to file a private lawsuit. They don't just have to go through administrative means to try to recover if there is some kind of violation. All right, Indiana has none. Iowa, this is a tax change. So the Department of Revenue in Iowa made modifications of their tax withholding tables to be more in line with changes that the legislature had made to state tax laws. So if you're in Iowa, rejoice. January 1st, 2021, you'll have increased take-home wages because the tax that'll be withheld from employee paychecks is going down. So if you are processing payroll in Iowa, make sure that you are aware of these new tax tables and withholding formulas, and make sure that you are withholding the proper amounts there. Kansas has none. Kentucky also has none. Louisiana, just one tiny little thing here. They passed a new definition of employee, which excludes independent contractors for the purposes of unemployment. So they just more fully, in most places, most states, exclude independent contractors from being able to get unemployment benefits. But Louisiana took the step of making sure it was codified and very clear that independent contractors in the state are not eligible to get unemployment benefits. All right, now we get to the M's. Every time I'm doing these presentations, I'm like, why do we have, there are so many M's. If I get past the M's, then I know I've made it about halfway through my 50 states plus DC list here. So Maine has some interesting things here. So first of all, their minimum wage is going up to $12.15 per hour. The tipped employee minimum wage goes up to $6.08. But now Maine, again, another state joining Colorado here, has passed an earned paid leave law. This takes effect on 1/1/21 as well. And actually, this paid leave law is not just for sick and safe time. It actually allows Maine employees to use leave for any reason that they might want to use it. So employers that have 10 or more employees have to allow employees to accrue 1 hour of paid leave for every 40 hours, up to 40 hours per year. It's not a huge benefit, but the unique part here is it's not a paid sick leave law. It's just a paid leave law, and it's job protected paid leave. So make sure if you're in Maine that you are updating your policies, that you're understanding, what employees can use this for, that you're not retaliating against your employees for using this leave, because like I said, it is job protected, and there's retaliation prohibitions written into that paid leave law as well. Maryland, Montgomery County just has a lot of its own laws as well. This law is pretty specific, so it provides that individuals working as a janitor, a building cleaner, security officer, etc., be given a minimum work week of at least 30 hours. I find this law to be very interesting. I've never seen anything quite like it. You've got to give those employees in Montgomery County at least 30 hours of work. So make sure your hiring is spot on, that you're not hiring more than you need, so that you can provide each person that is working for you with at least these 30 hours of time. The minimum wage is also going up to $11.75 for those companies that have at least 25 employees. This one is indexed to rise as well, and it goes up to the magical $15 in 2025. There's also a minimum wage increase for small employers, so those with less than 25 employees should be paying their employees $11.60 per hour. Massachusetts, again, similar story. They're raising the minimum wage to $13.50 till it gets to $15 an hour in 2023. That tipped minimum wage is also going up and is indexed to increase along with the standard minimum wage rate as well. So that's going to keep going up. And now, as of 1/1/21, all private Massachusetts employers have to provide paid family and medical leave that's funded through a payroll tax. So lots of states coming up with new paid leave laws that essentially take what is the FMLA and apply it at the state level and require that it be paid. So make sure if you have employees in Massachusetts that you are understanding all of the complexities and what's involved in this particular law. Michigan employees are going to see an increased minimum wage rate as well to $9.87, and the tipped employee rate is $3.67. That's a tough minimum wage, but again, that's for tipped employees, and a regular increase for non-tipped employees as well. Minnesota, a minimum wage increase as well, up to $10.08 for large employers and $8.21 for small. There's also a Minneapolis ordinance. I've seen this in a couple of different states as well, where there's new requirements for independent contractors that any contract for service be set forth in writing. But this Minneapolis Freelance Worker Protection Ordinance also has a new mechanism, an enforcement mechanism when a company fails to pay an independent contractor, and that needs to be included in that contract as well. So a couple of things if you're a Minneapolis employer and you have independent contractors working for you. Mississippi getting on the marijuana train. This is medical marijuana. I could see Mississippi being very far down the line and passing recreational. But as Mississippi voters, they approved this initiative, amending the Constitution, which creates a state medical marijuana program. Again, notably, there's no express protections for applicants or employees, and employers are free to maintain drug-free workplace policies, do drug testing, discipline employees for violations of that. So that remains the law there as well. We'll see if that changes. Missouri, minimum wage increase to $10.30 for non-tipped employees. They do have a separate minimum wage rate for tipped employees. St. Louis, this is interesting, passed a criminal background check ordinance that basically says employers can't use an individual's criminal history to make employment decisions unless that company can demonstrate that it's relevant to the employment-related decision. So thinking about if you're hiring a property manager who is going to work for an apartment complex, and they're going to have keys to all the residents' homes, and they're going to go in and do handyman activities, things like that. Well, if that individual has a long history of burglary, then, that is a relevant criminal history employment-related decision question. But if you're hiring a receptionist who has a DWI, does it make sense to exclude that person from a job or terminate them? Probably not. And so St. Louis has put in some protections for employees who may have some criminal histories there. Montana, again, minimum wage. Their minimum wage is based on what your business earns annually. So Montana residents earning minimum wage will get an increase up to $8.75. For tipped employers, if they make less than $110,000 annual, they're allowed to pay tipped employees $4 per hour. So a couple of different ways of looking at that. And again, another marijuana initiative. And this is a recreational use statute here. So there's a statutory initiative, which was I-190, and a constitutional initiative, which was 118. And neither of these laws provides express protections for applicants or employees. And so if an employee tests positive for marijuana, you're still free to discipline those employees. And specifically, that statutory initiative I-90, in very clear terms, permits employers to discipline, discharge, or refuse to hire an employee who is violates a workplace drug testing policy or is under the influence of marijuana while working. So employee protections are pretty clearly not going to be applied in Montana unless that changes. I've really got to pick up my pace here. I've got a lot left. Nebraska has none. Nevada, minimum wage is going up to $9.75 on July 1st. So this isn't a 1/1/21, this is July 1st. And tipped employees, they don't have a separate rate, so they have to make the $9.75. There's also some new mandatory safety training for employees that work at trade show sites and conventions. So thinking about all those massive hotel conference rooms and convention halls, employees that work in those types of sites are now required to get safety training. New Hampshire has none. Oh, always busy New Jersey. New Jersey's minimum wage goes up to $12, and the tipped minimum wage goes up to $4.13. This Senate Bill 3170 is expanding some advance notice and severance pay obligations under this law. This law has been kicked, the effective date has been kicked down the road many times because of the pandemic. It has become very difficult for companies to be able to provide that much advance notice, and it would be incredibly expensive to provide severance pay during the pandemic. So New Jersey has cut some slack to employers to say, hey, we understand extenuating circumstances. It's still possible that 1/1/21, the date could be extended again. It hasn't yet, to my knowledge. So if you're a New Jersey employer, make sure that you now have kind of a mini WARN Act. So if you're going to be laying off employees, make sure you understand what the notice requirements and the severance pay obligations are. More marijuana. Voters supposed to legalize possession of marijuana as other voter initiatives. This one is silent. Hopefully regulations and legislation come out shortly to let employers know whether there's going to be any requirements to allow or provide accommodations to employees using recreational marijuana. New Mexico has a minimum wage increase as well to $10.50. Tipped employees go all the way up to $2.55 on January 1st. New York, not as many things as normal for New York. I guess they got it all out of the way in 2020. Employee entitlement to use New York's statewide paid sick leave that was passed earlier this year begins January 1st, 2021. There's a new law for employees who have chosen direct deposit to be able to receive electronic confirmation of direct deposit in lieu of paper pay stubs. So that one comes out in April. So again, be aware if you are an employer with direct deposit, employees are going to be able to request that electronic confirmation as of April. So make sure your payroll provider is able to accommodate that. Minimum wage is going up. I find this one interesting. The standard minimum wage will be $12.50 in 2021, but it'll be $15 on July 1st for fast food workers. So fast food, very important in the state of New York. Officials also increased the New York City minimum wage to $15, but that was back in 2019. North Carolina has none. North Dakota has none. Ohio, again, just a minimum wage increase, $8.80 per hour for non-tipped employees, $4.40 per hour for tipped. Oklahoma has none. Oregon, doing some interesting things in Oregon. If you're a Portland, Oregon employer or company, make sure that you are not using facial recognition technology in places of public accommodation. This would be things like hotels, restaurants, basically anything open to the public. Make sure you're not using facial recognition in Portland. There's also minimum wage increases that go until 2023 with an increase up to $12.75 on July 1st. Oregon did break down into different categories their minimum wages, so make sure you're paying attention to if it's in the metro areas, if it's in the outstate areas. And here's one that really blows my mind. So Measure 110 decriminalizes personal possession of controlled substances like heroin, cocaine, and methamphetamine. So Oregon's saying marijuana is not enough. Let's go further. We're going to start allowing possession of a small amount of very serious drugs. Obviously to prevent overpopulation of prisons and jails because of drug possession, but it is still silent with respect to employment. I highly suspect employers are not going to need to accommodate a positive drug test for heroin or cocaine. Now, it's Oregon, so don't trust that is absolutely the way it will go, but we're still waiting for more clarity on what that means for employers. Pennsylvania, this is really more Philadelphia, Pittsburgh that have gotten into passing things here. Both Philadelphia and Pittsburgh have laws regarding paid leave due to COVID-19. Philadelphia has one relating to healthcare workers, since healthcare workers are excluded under the FFCRA, so make sure that you are aware if you have employees working in either of those two cities. There's also the city of Pittsburgh and Allegheny County have passed, and this was back in October, but they passed what's called the Crown Act, and that prohibits discrimination on the basis of hairstyle. So if you have employees in Pittsburgh or Allegheny County, make sure you've got hairstyle as a protected class in your employee handbooks. All right, Rhode Island has none. Carolina, this was effective back in August 23rd, but I wanted to point it out in case it was missed. So employers have to provide an employee with reasonable unpaid break time to express breast milk. So this one is unpaid, but it was new relatively recently. And you have to provide a room other than a toilet stall or bathroom as a place where an employee can express breast milk in privacy. South Dakota is on the marijuana train as well. They both create both a medical marijuana and a recreational marijuana ballot initiative. Just like the rest of them, it does not state whether employees will be required to accommodate that use. I suspect legislation or regulation will come out and give us clarity on that as well. And the minimum wage goes up a whole 15 cents to $9.45 per hour. Tennessee, this is again an older law, but make sure that if you are revising your handbooks for 2021, that you make sure that you are, or you're doing supervisor training, make sure you're touching on the new Pregnant Workers Fairness Act. This went into effect on October 1st. And again, I think with all of that, everything that's going on with COVID, just some of these things that came out late last fall got kind of glossed over. So make sure if you're in Tennessee, you understand that Pregnant Workers Fairness Act, update your handbook, update your supervisor training to make sure that you're covering this issue. Texas has none. Utah has none. See, with these, we're going to get there. We're going to get there in a year. I think I'm going to be done early unless you guys have all sorts of questions for me, but I'm getting close. So in Vermont, the minimum wage is going up to $11.75 per hour. Virginia's got a few things here. Minimum wage going up to $9.50, but that's on May 1st. So make sure you understand, create a tickler for that. One thing that states have been doing, California kind of started the trend. Others might pick this up, but the Virginia House Bill 1407 creates a presumption that a worker is an employee unless either the worker or the employer can prove the independent contractor is properly classified under federal IRS guidelines. So if you're in Virginia and you utilize the services of independent contractors, I would say it's a great time to go through and do an analysis of those independent contractors to make sure that you've got them properly classified. Because if you have them misclassified, there are new types of civil penalties. There are other prohibitions against contract awards from public entities, etc., for violations of this. So Virginia stepping out to protect employees from misclassification as independent contractors. And, because I do have time, why not a little aside? Employers who have, during COVID, been allowing employees to work from home have looked increasingly at hiring employees in new states. And one question our attorneys get a lot is, hey, we're going to hire a new employee in the state of Virginia, and we don't have any other employees there. Can we just call them an independent contractor so we don't have to mess with new taxes, new payroll laws, new, paid meal break laws, things like that? And I can see why that might be an attractive option, but it is illegal. And misclassifying an employee as an independent contractor carries a ton of penalties if you get caught on that. So as attractive as it might seem, if you're going to hire an employee in a new state, you're going to need to comply with that state's laws. Plus, you can really prove that that person is an independent contractor and not an employee. And it's a tough hurdle to get over. That federal IRS guideline, that's a 20-part test. It's a balancing test, but it's 20 parts. And so just a little aside since I had the time. Also in Virginia, anybody is prohibited from holding a handheld personal communication device, i.e. cell phone. So make sure you are looking at any distracted driving policies that you might have in place. Washington, very busy. This House bill prohibits denying employment to a care provider where a background check reveals that the individual has a finding of child abuse or neglect in their record, but has since gotten what's called a certificate of parental improvement. So if you are an employer who, hires child care educators or providers, make sure that you're aware of this bill. Seattle has a local payroll tax for employers doing business in the city of Seattle that's effective 1/1/21. So if you have a business in Seattle, make sure that you are making sure that you are withholding that new local payroll tax. This is a new law for employers that have retail, security guard, and property service contractors and hotel and motel employers. So if you have isolated workers that are housekeepers, security guards, janitors, there's some new sexual harassment and assault prevention requirements that you need to put in place. Some of those being a panic button for isolated workers, a way for them to, in an emergency, get a hold of somebody for help. So if this is you and you are one of these employers, make sure you're complying with all of these, as of 1/1/21. And then some minimum wage increases statewide to $13.69. CTAC is up to $16.57. And then Seattle, depending on size, is either $16.69 or $15. West Virginia has none. Wisconsin has none. And Wyoming, our last state, has none. So, I can't believe I got through it. That was great. All right, so let me see if I've got any questions here. And so it says, how does Colorado's new pay equity law work for those who are working remotely? I don't know that detail off the top of my head. I'm happy to look into that and write you back. But yeah, I don't know that answer off the top of my head, unfortunately. All right. Any other questions? Feel free to put those in here. I will follow up with this one person who has the question that I just unfortunately don't know the answer to. Here's one. We have one employee in Colorado, but company-wide we have 80 employees. Do we only count having one employee or 80 employees in Colorado? Same question for other states. Do we only count the total number of employees in that state? All right, here's how complicated this is. So every law, well, just about every law, is going to tell you when it applies. So, for example, some laws would apply if you had 5 employees in one state. Some laws would apply if you have 1 employee in that state. Some laws don't count the remote states. They actually have you count where the employee reports to. So figuring out for example, if you have 1 employee that works in Colorado, maybe they went remote when COVID started, they moved there, and because they have family there, for example. Some laws are going to apply to them and some are not. And that is why multi-state employers have so many difficulties, because you have to look at each law on its own to see whether it's going to apply. It is not an all or nothing situation in most instances. So unfortunately, I can't answer that question because it does depend on the law that's involved. And I know that's not a lovely answer. I wish it was just one way or the other, believe me, because it makes it very difficult for our attorneys as well. Every time a company moves into a new state, we have to know how many employees, how long have they been there. Okay, because of that, these are the laws that apply. So complicated question. I'm sorry I can't give you a really easy answer on that. All right, any other questions? We're right up to noon. Like I said, can't believe I got it done. And, might be, depending on what happens with the legislatures this spring, I may do a July 1st, 2021 legal update. It's really helpful especially if you're a big multi-state employer, for you guys to know kind of what to be watching for. It's difficult for our attorneys even to stay on top of it. So I cannot imagine how difficult it is for HR departments. So if it would be helpful, and we are seeing a lot of state laws getting passed effective for that date, then I'll probably do this again. But all right, we'll watch for the third Tuesday presentation for next month. In February, we are doing an HR 101 seminar. This is really meant for those folks that might be brand new to HR and are really needing a primer on FMLA, ADA, wage and hour, all of that. So we're going to be doing that in February. Be watching for some information about that to come out, and feel free to share it with anybody that may want to attend. And otherwise, watch for our email. It'll have the HRCI credit code, the recording, the slide deck, all of those great things. So thank you so much for joining us again today, and I hope you guys all have an awesome rest of the day.